his resources. For a clearer picture on that, we are now joined in the studio by Mr. Arjun Kapoor, who is the Managing Director of ARK Securities. Thank you very much, Mr. Kapoor, for joining us. How does the budget change the picture for somebody with income to put away?
Couple of things. संगठन में भाग लेने के लिए और इसी आधार पर अनेक विश्वविद्यालयों और विद्यालयों में संघ की शाखाएं लगती हैं और बहुत प्रारंभ काल से लगती हैं, इसलिए अगर कहीं ये शाखा लगती है तो कोई आपत्तिजनक बात नहीं है.
In Uttar Pradesh, the RSS already runs shakhas in a number of institutes and colleges, but the decision to include Lucknow University looks set to spiral into a huge political debate. With Kamal Khan, Barkhadat, Star News.
Well, coming up next on News are India Matters, and we take a hard look at India's legal system tonight.
Today we examine how the long wait for millions, it's mostly a case of justice delayed, is justice denied.
Perhaps the single most pressing problem facing the judicial system today. There are more than 30 million cases pending in courts, a sign that the system is overburdened and perhaps even incapable of handling the growing number of cases that come to courts. So how then can we meet the challenge and ensure that justice is given out to those most in need of it? Rashika Kaul finds out.
63-year-old Ramesh Kumar is a man in search of justice. His case, a property dispute, comes up in the district court frequently, but chances of resolution appear bleak. First filed in 1974 by his father, the case has over the years seen innumerable hearings and adjournments, and 27 years later, the trial is yet to begin.
During the 27 years pendency of the suit, 6 persons have already died. The situation is very bad, I am not getting the justice. I come to the court and go back. I have engaged so many lawyers, I have spent so much amount. All my savings practically, as I have told you, I have spent. I had to sell my plot.
Even those involved in criminal cases have to wait years before their case comes up for hearing. Perhaps the worst sufferers are under trials, who at times spent more than 20 to 30 years in jail, waiting for the trial to commence. There are about 3 crore cases pending in all the courts in the country, which means the involvement of 6 crore parties. Out of this, more than 2 crores are civil cases and 1 crore are criminal cases. Experts say there is a need to make changes to the existing law, most of which are outdated, complicated, some even obsolete.
Law procedures, they should be improved. You see, for instance, Indian Penal Code itself is the main thing for all criminal cases in the courts in the country. Indian Penal Code, it is 1860. It was formulated in 1860 and we are now in 2000, year 2000. And 140 years ago, a thing which was formulated is still relevant. And there are certain sections in it of punishment. The maximum punishment that can be given is 500 rupees in that. What is 500 rupees now?
But perhaps what really needs to be revamped is India's legal infrastructure. The judiciary is grossly overburdened. There are only 13,000 judges for a population of 1 billion people, which means on an average, one judge has to hear 50 cases a day, whereas in countries like the UK, a judge hears not more than 8 cases a day.
Mere legislative changes, as have been done in the recent CPC, are not a total answer. They have to be part of a larger, multi-pronged, multi-dimensional, holistic strategy, which must include appointment of judges, better infrastructure, a far greater expenditure on judiciary as part of the planned expenditure, better courtrooms, better libraries, greater staff, computerization and all that.
But many in the judicial community feel that the presence of more courts and judges does not automatically translate into better justice.
I think a continuing legal education is a must, not only for lawyers but also for judges. Because a lawyer without, not properly equipped today, is like a doctor who is not properly equipped today. And this is a very fast moving world. Everything is changing and we require to know more and more. Judges also require to know more and more. And therefore, I think that it requires a degree of competence, a degree of dedication, a degree of idealism to try and see that the justice delivery system is not only speeded up, but it affords a measure of justice at a reasonable cost to most people.
Another key area which is yet to be given proper attention is the need to develop alternate dispute resolution techniques. This includes methods like arbitration, mediation, lok adalats and even conciliation, which would help resolve cases out of court. Legal experts say there are many cases which can be resolved outside court, especially civil cases. In the US, for instance, only 5% of criminal cases ever go to trial.
If, for example, out of 3 crores, you're able to settle even 25%, and remember, in California, which is the system we studied before this change was proposed, 95 out of 100 cases do not go to trial. They are, out of those 95, maybe 90 are settled by mediation, conciliation, consensual talk outside the court. 5 more wither away or die out. But the system works because only 5 go ultimately to trial. Now, if you have a 95% rate there, if you assume even 25% in India, you'd be lopping off 1/4 of this huge arrears of 3 crores.
The government's decision to amend the Civil Procedure Code is the first step towards improving and expediting the judicial process. But along with that, there is also a need to revamp and reorient the legal system so that efficient and prompt justice can be delivered to the public. Rashika Kaul, Star News.
A long wait for justice there. Well, joining us now is Senior Supreme Court lawyer, Mr. Abhishek Singhvi. Abhishek, thanks for joining us. Abhishek, really some important points made there in the story about the need for judicial restructuring. What really do you think are some of the main sort of areas that need to be looked at to make sure that justice is speedily delivered?
Well, as you saw, I think it has to be multi-pronged and holistic. Clearly, one very important area is to have more judges. We have the lowest, one of the lowest judge population or judge litigant population ratio in the world. In this vast country, we have a total, I think, of not more than 5,500 or 6,000 judges.
Right.
Clearly, appointments, you cannot have a huge amount of patients and too few doctors or hospitals. So it's as simple as that. That's one area. We need to ensure that existing slots for judges are expanded. You have far more posts. And secondly, we need to ensure that the existing posts are not kept vacant as they are today for several months, indeed years, after retirement of a judge from a particular post. Secondly, of course, infrastructure, very important. And this is most important at the cutting edge of our judiciary, the lowest courts, the 500 odd district courts and civil courts. There, what to talk of computerization, computers, you don't have proper chairs, tables, stenographers, filing cabinets.
So really basic sort of...
Yes, and there if you were to have across the board computerization and court management techniques, you could have batching, classification of cases of similar points together, retrieval. Today, for example, out of this so-called 30 million backlog, probably as many as 1/3 or maybe 1/4 would be infructuous. A large number of cases are merely numbers on a file.
But Abhishek, you're talking of more judges. Now, it would seem that if you have a single judge who has to hear many more cases in India than in other countries, the cases would actually be heard and disposed of quickly. But what we really seem to have here is a case where you have repeated adjournments, the same cases drag on for years. Now, isn't that something which is not just to do with the number of judges?
No, therefore I said multi-pronged and holistic.
Right.
The first prong, of course, is more judges. Second is better infrastructure. But third, of course, is law changes in both procedural and substantive law. And some of those changes are in the proposed current CPC amendment bill. There are a few which are objectionable, maybe 2 or 3. But by and large, the vast majority of them are desirable. Take, for instance, adjournments. In the case of adjournments, there have already been very potent weapons existing on our statute book, permitting the judge to take strong, stern action against unnecessary adjournment. And I believe that if a judge was to use the potent weapon of costs on a regular basis, there would be very few adjournment problems.
Right.
But then again, this bill has several other simple good things. For example, moving out the entire evidence collection system out of the courtroom. the vast majority of time of our original side civil court, so to say, is in recordal of evidence in chief and cross-examination. Now all of that is to be done by commissioners outside the court system. There's no reason why that shouldn't be done. And lastly and most important, I would like to view the whole system as a pipeline, so that one object is to get cases coming into the pipeline at one end to move faster within the pipeline and come out at the other end within, say, 2 years or 1 year. But equally important is to decongest the pipe by moving cases out of the pipeline and subjecting them to what is called ADR, alternative dispute resolution, or consensual dispute resolution, CDR.
The point Mr. Nariman was also trying to make as well.
And dispose them off. And that is another part of this new amendment, so that you take matters out of the system and you subject them to mediation, for example, or conciliation. Or
but yet we have
arbitration.
lawyers going on strike against some of these amendments.
Let me clarify that why I am very much in support of most of the amendments, barring a few which I think are not quite right. I equally support the lawyers' right to dissent, and certainly what we saw on television channels in terms of police brutality on persons demonstrating is not quite acceptable.
Well, I'm sure many of the problems of infrastructure which you mentioned here are perhaps most acute in the subordinate courts.
That's exactly, in fact, the Supreme Court judgment on the subject in the All India Judicial Officers case has tried to rectify that by providing mandamus to all states to provide things like libraries, travelling allowances, good houses for judges.
Right.
Some of our magistrates and district judges who handle cases of unlimited pecuniary jurisdiction have to actually hang from a bus while travelling. By creating within the Bar Council, by the Bar Council, a separate independent, a highly independent and high-statured disciplinary body comprising lawyers, judges, ex-judges, a combination, a small number of persons known for their integrity and objectivity.